Hello, my name is Melanie Barnes and I'm a solicitor at Turpin and Miller Solicitors in Oxford, England. And today I'm going to be talking about the maintenance regulation. That's regulation 4/2009 that was introduced in all 27 EU member states on 18th of June 2011. We're probably all familiar with the maintenance regulation by now and are starting to see a few orders come through. I've dealt with a few enforcement orders, but as of yet haven't seen many applications for new orders in England and Wales. But I thought it might be helpful today to have a brief overview of the maintenance regulation and then look at where applications are issued and what the procedure looks like going through the central authority. So looking first at the key aspects of the maintenance regulation. Well, first of all, there's a choice of jurisdiction, and that extends the scope. So although previously the defendant was always sued in the state of their domicile or habitually residence, now the creditor has a choice to either bring proceedings in her own jurisdiction or the jurisdiction where the defendant is living. And that means that he or she can look at whether they want to have a new order and look to enforce it in the other country, or perhaps ask the central authority to make an application for new maintenance in the other country on their behalf. And that's because the main purpose of the maintenance regulation is to make obtaining maintenance for a spouse or a partner or a child much simpler and easier, without there having to be a number of special procedures or hoops to jump through. The second key aspect is the opting in of the Hague Protocol 2007. And the Hague International Recovery of Maintenance Convention was negotiated by countries at the same time as the EU maintenance regulation, which is why many of the provisions and the terms used are almost identical. And the Hague Protocol was opted in by 25 EU member states, and UK and Denmark decided against the applicable law. And the Hague Protocol sets out what law should be applied when an application is brought in a member state. And it basically says that the applicable law is that of the law where the creditor is habitually resident. So, for example, if the creditor made an application in Poland for maintenance, then the court in Poland would say, well, the applicable law is that of England and Wales, if that is where she was based. And England and the UK and Denmark both said, well, we don't really like the sound of that, and we just want to apply local laws. So whenever an application is made in this jurisdiction, our local laws will apply for maintenance. The third main aspect is the abolition of ex equatur, and that relates to the registration process that was applicable under Brussels I. So what would happen is, say an order was made in the UK and it's sent over to Spain to be enforced. The court would want to have a declaration of enforceability, and it would go through a registration process which could be challenged. Now, that hasn't actually changed for the UK and Denmark because they've opted out of the Hague Protocol. So whenever we've got orders going out for enforcement, they still go through a process of registration which can be open to challenge. But for all the countries who opted into the Hague Protocol, say we have an incoming order to the UK, under the maintenance regulation, no special procedure is required, which is set down by Article 23, and that means that there's no registration process, save where there's transitional provisions. So just looking at when the maintenance regulation would apply, for orders before 18th of June 2011, the maintenance regulation is still relevant, it still applies, save for the registration process under Brussels I. So what the transitional provisions basically say is maintenance regulation applies for all proceedings, save that where that order or the proceedings were commenced prior to the introduction date, 18th of June 2011, the Brussels I registration will apply. And the fourth key aspect of the maintenance regulation is cooperation between the member states, and that's something that's repeated in the Hague 2007 Convention. So what we're seeing is lots of special requests and special measures being put in place, which means that queries or documents can be requested from another country. Our communication should try to be swift, electronic if possible, by way of email. And the overall purpose, as I said, was to make sure that maintenance can be obtained and enforced without delay. So where are proceedings issued? Well, as I mentioned before, there's a choice of jurisdiction. The creditor can choose her own country or the defendant where he is based. Now, Article 3 of the Maintenance Regulation actually refers to the defendant and not the debtor, and that's quite clever drafting, because what it does is it basically prevents the debtor from issuing against himself and trying to forum shop. And there was a lot of discussion about forum shopping, but the way it is set up, it actually looks like the creditor is the one who can bring a new application if she moves to another country or is habitually resident for a short time. So the application would be brought in one country or the other for a new application of maintenance or for enforcement of an existing order. So going back to our example before, a mother who may be the creditor may live in the UK. She could go to her local court, issue proceedings here, private proceedings under our Children Act 1989 for a lump sum for need. And then she could enforce that through the central authority. Or she could go to her local magistrate's court and have their assistance to make an application in Poland where the father is living. And the court there, or the central authority on her behalf, would issue proceedings for maintenance in that country. There are also limitations on the debtor on when he can apply for a modification or a variation, and they're provided by Article 8 of the Maintenance Regulation. They basically say where the creditor remains habitually resident in the country who made the initial decision, then an application for a new order or a modification cannot be brought by the debtor or the defendant. So if we look at our example where, say, the father is in Poland, then if an original decision was made under the Children Act in England and Wales, in the UK, then the father would not be able to, say, move to Germany and make an application for a new order for maintenance, because that country would still be seized and that order would still have force. There are also provisions in the Maintenance Regulation for parties to agree jurisdiction, save where it relates to child maintenance for a minor under the age of 18. But say they have a prenuptial agreement or a fatherhood agreement and they want to set out what they would owe each other as partners, then they can agree to go through a certain court or member state. And we're seeing a lot of those types of agreement in England, where, say, a nuptial agreement was entered into, and under that agreement they've decided that, say, the law of Germany will apply, and that if there is any dispute, then proceedings should be issued there. There are still going to be jurisdictional issues, though, because under Article 3, it's the habitual residence of the creditor or the debtor for enforcement. So although a decision might be able to be made, there still might be issues about where enforcement proceedings can be brought. Article 5 also provides that if the defendant makes an appearance in a court and in a way submits to the jurisdiction of the authority in a member state, then they will also have jurisdiction. And when no state have jurisdiction, Article 6 provides that the parties' common nationality, so it's not the nationality of one of the parties, but their common nationality, say both were Irish, then that state would have jurisdiction. And also if there's problems such as a war, then forum necessitatis will give another member state jurisdiction to deal with the application or enforcement of maintenance if there is some connection. So it's not possible for you to simply pick and choose one of the member states in the EU. There has to be some sort of connection, say because some assets are owned there. So in terms of procedure, we're looking into choice. A person, if it's allowed, under the law can make a private application. They can pay lawyers to issue proceedings in one country, so long as there's jurisdiction. And then they could seek to enforce it. But there's also provision for applications to be made through a central authority, and those known as the Article 56 applications. Now they're different for the creditor and the debtor, and that's because the creditor can apply for a new order for maintenance, but the defendant is limited. So under Article 56, a creditor can apply for recognition or a declaration of enforceability. So for example, that would be necessary if an application was being enforced in from the UK or Denmark. She can apply for modification of an order. He or she could apply for enforcement of an existing order. For a debtor, he or she can only apply for, say, a stay of proceedings, something to limit the decision of enforcement, and modification. And those are the applications that are available through the central authority. Lis Pendens rule. As with Brussels 1, if there are proceedings in one state, then another state can't then deal with the application. Now this is where it might get a bit tricky, because if the member state has jurisdiction because they're dealing with the divorce, and that is provided for by Article 3 when they're dealing with the status of person, say with dissolution as well, then they also are able to deal with maintenance. But some people simply just put in the application for divorce, and that means that the claim for maintenance is kind of up for grabs. If another member state had jurisdiction, then either party could then apply for. So you might get a situation where, say, the divorce is being dealt with in England and Wales, and then an application is made in Germany for the maintenance. In lots of situations, the divorce and the maintenance will be applied for together. And say with parental responsibility, which also depends on the habitual residence of the child, the court could also deal with maintenance. So if divorce proceedings are in one state, then it's not dealing with maintenance, so there wouldn't be a lis pendens issue. But if finances were applied for, say Form A had been filled in and completed, then another country must stay their proceedings if they're lodged. So for example, we've got an ongoing financial case in England and Wales. The other party issues proceedings for maintenance in France. The French court shall, so there's no discretion, they shall stay their proceedings. And that can cause problems which we're already seeing in the UK. For example, under the 2011 case of Schofield and Schofield, a pension sharing order was made by Germany. And when it came to enforcement, the pension provider said, well, we need an English order. We can't deal with, we can't put a pension in place with a German order. And because maintenance has already been dealt with, and Germany is the court with jurisdiction under the rules of the maintenance regulation, there's no way that new proceedings here could be issued just to deal with the pension, because it's already been dealt with, which is a res judicata issue as well. So what we're seeing here is all of these floating orders that can't be dealt with. Now what needs to happen really is the government need to make some rules so that they can be dealt with, and I am sure that that will happen in time, but for now it just means that those pension sharing orders can't be put into place. There's another interesting case called EA and AP of 2013, which I understand is ongoing, and the facts of that case were the husband and the wife were both Italian by domicile, but they were both habitually resident in the UK, where they lived with their children. Now they separated in the UK. The husband issued proceedings for divorce and finances in Italy. Now under Article 3, that means the Italian court can deal with maintenance, and they held that they were seized for spousal maintenance. And what the Italian court said is that yes, we are seized of the maintenance application for the spouse. But because the children are habitually resident in the UK, the English and Welsh court have to first deal with the children arrangements, and they also need to deal with child maintenance. So The problem in that situation also is where the father, the mother and the children are all habitually resident in the UK, then the Child Support Agency, which is the UK Administrative Child Maintenance Agency, will have jurisdiction to make a calculation of maintenance. So in a way, if an application had been made to the CSA, then that would have prevented the Italian court from dealing with child maintenance. But would it have prevented them from dealing with spouse maintenance? Well, it's not distinguished in the maintenance regulation, and they're not seen as distinct things. Maintenance is just seen as financial provision for creditors and for children. So it'd be interesting to see what happens in the future when we have this kind of situation. And it also raises the question of when the creditor can make an application for a new order. Say, for example, the Italian court was seized for all maintenance and made an order, then can the creditor simply turn around and say, well, I've got habitually resident somewhere else, I'm just going to apply for a new order in this country, which makes the race for jurisdiction a bit redundant, because actually all the creditor needs to do is simply wait and then make an application to vary or for a new order in that other country. Direct enforcement. When the maintenance regulation first was introduced, I think a lot of practitioners, including myself, understood it to mean that you would be able to get an order from another member state, rush down to your local court and say, I'd like to enforce this please, and no special procedure would be needed. But that's not actually the case. Although registration has been abolished for all outgoing orders for the UK, registration is going to be relevant, but also our central authority has stopped accepting direct applications to the central authority, which were available under Brussels I. So just to explain that a little more, if there's an application for enforcement, then under Brussels I, say the Youth Welfare Office in Germany, who deals with enforcement, would simply make an application to REMO, to the UK Central Authority for enforcement. REMO would then send that application to the local court, to the defendant, and a judge there would make a decision on how to enforce that order. What the central authority are saying now, not as a matter of law, but as a matter of policy, is that they don't really want to accept direct applications. So, for example, if I was instructed as a solicitor to act on someone's behalf, then that creditor would still need to go through the central authority of their member state, over to the UK Central Authority and to the court. So, in fact, there's more delay now because those direct applications can't be made straight to REMO, which is a real shame. And the reason they can do that, and it may be similar for other EU member states, is that the country can define who their competent authority or competent court or administrative body is. And one of our administrative bodies under Annex 10 is the Child Maintenance Service, previously known as CMIC, previously known as the Child Support Agency, but also the Magistrates Court. So Article 27 says that the declaration of enforceability shall be submitted to the court of the competent authority. That's identified in accordance with 71, and that is the Magistrates Court transmitted from REMO. Now that's reflected in the more recent Civil Jurisdiction and Judgment Maintenance Regulations 2011, which provide that the competent court is the Magistrates Court, and under subparagraph 2, to be transmitted to the Magistrates Court by the Lord Chancellor, and that's REMO. So I can't make an application direct to the Magistrates Court. It has to come from the central authority to the Magistrates Court, and the central authority won't accept direct applications. So really, the only applications that are available through maintenance regulation are Article 56, through the central authorities. And that may mean that there's several months added on now while it goes through that additional process, because I understand that all central authorities at the moment are struggling to deal with the amount of applications that are now being made. For example, REMO has gone up from, say, around 1,300 orders to about 2,000 orders in the year end March 2013. So they're seeing a massive increase of incoming and outgoing orders. Just while we're talking about REMA, we talk about the kinds of duties that they have. Well, the maintenance regulation added that they're not just there to transmit, there are duties to make sure that maintenance can be obtained. And we briefly mentioned before the special measures that can be applied for, which is a really interesting part of the maintenance regulation and the Hague Convention. So, for example, if I, as the creditor, don't know where the father of my child is living, then I can apply to the central authority so that they can make queries of other countries. I may have an idea that they may be in Spain or in Portugal, and so the central authority can ask Spain and Portugal if the debtor is living there, and also provide information about their income and about their assets, so I can make a decision about where to bring that application or what next steps I take. They're also there to facilitate obtaining of documentation and to serve documents. So those are all the provisions of Article 51, which set out all of the things that a central authority needs to do. So how are applications made? Well, the forms for the applications are annexed to the maintenance regulation itself. And every time I print out the maintenance regulation, all of these forms come with it, because I keep forgetting to limit the document to about 20 pages. And I didn't really read them for a while, but it's worth having a closer look at the headings and also the forms themselves, because they will tell you a lot about the types of applications that can be made through the central authorities and in other situations. So for Section 1 orders, now Section 1 of the maintenance regulation is where the country has opted into the Hague Protocol, and so there's no registration process. So they will simply give information about the decision or the order, and that will come in with an Annex 1 form. For the UK and Denmark, or those under transitional provisions under Brussels 1, the registration process applies and an Annex 2 form is needed, and that has details of the decision, what needs to be enforced, and that form will then go to the central authority to be transmitted. If that application is being made for arrears owed to the Child Maintenance Service, that decision won't carry on, but arrears can be claimed. Then it's recently been decided that the Child Maintenance Service is the organisation who completes that Annex 2, and then the application gets sent by the creditor to REMO and then on to the other country. And the other forms, such as the special requests, are also in annexes, and they can be found there. In the UK, our forms are referred to as REMO 7 and REMO 8, but they're both the central authority forms, and I don't know how often they've actually been used by practitioners. Legal aid is available for applications for child and spousal maintenance, but as far as I know, it's never actually been claimed, and that may be because all of the applications are going through the central authority. Legal aid for advice, which is legal aid lower, is available, and legal aid for representation at court, legal aid higher, is also available. That's available in two situations. First, for Article 56 applications, and second, where free legal assistance has been available in the country of origin. So, for example, in Germany, if the youth welfare officer is enforcing on behalf of a creditor, then that creditor, who is a child, would be entitled to free legal assistance. That means that that child is able to have legal aid in this jurisdiction. Although it's only a small fixed fee amount, it will mean that they can obtain advice and have someone represent them in court. So as we've seen, there's actually been very little difference in the actual procedure for enforcement of maintenance orders. And actually, in some situations, there's been added delay, say because under policy reasons, direct applications to the central authority are no longer available. Also, for the UK and Denmark, outgoing orders are still open to a registration process. So in lots of situations, there's very little difference with how applications are dealt with. However, it has opened up a lot of discussion between EU member states. It feels like practitioners are much more aware of how jurisdictions and other countries deal with applications, and that's really positive, especially with the Hague Convention and all of the new duties on the central authorities is going to make the process a lot more efficient in the future. I have a real interest in international enforcement, and I am really happy to help anyone who needs some assistance. So please do not hesitate to email me or contact if you need any support or advice in applications, and hopefully you'll be willing to offer me the same. Thank you very much.